Well, good morning, everyone, and welcome to the Fasken Seminar on the Ontario Not-for-Profit Corporations Act 2010, a modern era for not-for-profit corporations in Ontario. My name is Lynne Golding, and I'm the head of the Health Law Practice Group at Fasken. I'm a corporate lawyer who does a lot of work in the charities and not-for-profit area. And I am joined today by three other Fasken lawyers, all from our Toronto office. So first of all, we have Laurie Turner, who is a partner in our group. She does a lot of work with for-profit and not-for-profit corporations. We have Victoria Mitrova, who is one of our mid-level associates. Victoria does a lot of health regulatory work and is also doing a lot of work in the not-for-profit and charitable sector. And finally, we have one of our brand new associates, just started back as an associate, Briana Maguire, who is going to be speaking to us as well. So you may have noticed, or you will notice, that all of us speakers have something to do with health law. And that is because most of our health law clients are charities and not-for-profits. And so we have a lot of expertise dealing with them. And of course, we're happy to and are frequently called upon to apply that expertise to those in other sectors. So the way this program is going to work today, we're going to start with 4 presentations. I'll speak to you first and I'll tell you what that's about. Then Laurie is going to be speaking to you about members and members' rights. Victoria will be speaking to you about directors and officers. And at the end, Briana is going to spend just a few minutes speaking about how the rules that apply to most non-share capital corporations in Ontario are a little bit different for hospitals. And that'll just be 3 or 4 minutes. So don't hang up, even if you're not a hospital, stay on board, because then we're going to have our Q&A session after that. So just a little bit of housekeeping for all of you. First of all, there is a button on the bottom of your screen for online surveys. We would really like it if you fill that in at the end of the seminar. It really helps us determine what our programs should be for the future. There are some materials for you. There's a materials button, and from there you will be able to get this PowerPoint presentation, and you'll also be able to get this really good bulletin that we put out about 2 or 3 weeks ago, which is a really comprehensive summary of this statute. A couple of other things. First of all, you may have questions for us. Some of you sent in questions ahead of time. That was great. I think you'll find that we have answered all of those questions in our presentation. But if you have other questions that come up, please do just put them in the chat and we will deal with them in the last portion of our seminar. If you need any technical support, you'll see that there's a technical support chat button. Just enter your question there and one of our techies will help you. We're still in COVID, and so I want to let you know that we have lots of materials available for you about COVID-19. Go to our website. There's a real wealth of resources there. So I think that is all of the housekeeping. We can now get to our actual program. So I'm going to start by giving you a bit of a background about the Act, how you transition into it, and I'm going to talk about some different categories of corporations under this Act. But before I do, I want to tell you about some nomenclature. So as we go through this webinar, you may hear us refer to the Act by its whole name, although I doubt you'll hear that very often. You might you may hear us refer to it as the Act, or the ONCA, or ONCA, and sometimes you might even hear us call it the new Act. Although, as you look at this, you can see that this Act was put on the books of the legislature 11 years ago in 2010. So that doesn't seem very new. But of course, we're putting this in a perspective. So Nick, if you can go to the next slide, please. We have to compare this new Act that we have now that came onto the books in 2010 to the Act that preceded it, the Ontario Corporations Act, which was promulgated in 1907. So, you know, it's a really antiquated Act. It's been amended over the years, but it last had an overhaul in the 1950s. It's a really laborious Act. You'll all know that it was very difficult for the longest time to have members' meetings called electronically. To this to this day, there is really no flexibility for relief from audit requirements. There are very few members' rights. So we're into a brand new modern world where we'll have all of that available. This new act, as I call it, is very much modeled after the act that applies to for-profit corporations, to business corporations. It's similar to, but it's not the same as the federal counterpart for Not-for-Profit Corporations Act. As you can see, it came out of the books in 2010, but it was only brought into force last month on October 19th. Next slide, please. So I'm going to tell you that in my humble opinion, this act has the wrong name. I think it should have been called the Nonshare Capital Corporations Act, because what it has in common for all of these companies that we're going to be dealing with is the fact that they do not have share capital. Some of them are not-for-profits from a tax perspective. That is, corporations that are formed for a purpose that is not to make profit, but who don't qualify as charities. So it will apply to those entities, and it will also apply to charities, registered and unregistered charities, charities that are charitable organizations, public foundations, or private foundations. The only non-share capital corporations incorporated under the laws of Ontario that will not be covered by this act, at least not at this time, are railway companies, cooperative corporations, and entities that are called corporations sole. These are government type entities. If you have one, you will know it. And otherwise, don't worry about those sorts of entities. We can go to the next slide, please. And the next slide, please. So in terms of transitioning to the act, the good news is you don't have to worry about taking any steps to be subject to this act. This act and all of the conveniences that are in it are immediately available to you. Now, that being said, if there is something in the statute that conflicts with something in your current articles or bylaws, then your articles or bylaws will continue to apply for the next 3 years until October 19th, 2024. But otherwise, the statute will be in effect. So what will happen 3 years from now, if you haven't amended your letters of patent or bylaws, then they will be deemed to be amended to reflect the act. That's going to be really messy for you, right? Because we want to be able to look at our governing documents and know that what they say is actually what governs us. So obviously, we strongly encourage people to amend their letters of patent and their bylaws before that 3-year period is up. And I'm going to talk to you about how to do that in a minute. So having said that, 3 years from now, if there is that inconsistency that the new act will prevail, there are some exceptions to it. So we can go to the next slide, please. To the extent that your current articles or bylaws contain clauses that deal with these matters here, which I'll go over, then even after 3 years, these clauses will continue to apply. But this is only in respect of these clauses that are in your letters patent or bylaws now. If you amend your letters patent or bylaw for any purpose whatsoever over the next 3 years, you'll be required to fix these things. You can't, amend your bylaws for other purposes, but leave these clauses here, hoping that in 3 years' time, they will continue to apply. So this is a special rule for clauses that are already in existence. So anything to do with the number of directors you have, if you don't change that, then even after 3 years, that will be the case. Anything to do with various groups or classes of members, voting rights for members. If you have a delegated membership system, that too can continue to apply, and provisions that you have pertaining to the distribution of assets on a dissolution of the company. Okay, we can go to the next slide, please. So as I say, we highly recommend that over the next 3 years, you amend your articles or rather your letters patent and your bylaws to be in compliance with the new act. Now, it's going to take some work to do that. So probably it's a good opportunity to look at your documents for other purposes too, and kind of fix them all up at the same time if you can. So I think you should read through your letters patent and bylaws and check and see, do these reflect our current activities and our current processes? If they don't, you should probably be changing your activities and your processes or change these documents to reflect the reality. I think you should look at the documents and say, do these reflect current best practices? Again, if they don't, this is an opportunity to rectify that as well. Now, before you start that kind of exercise, you have to give some consideration to a few other things. Who's going to lead this process in your organization? Is it going to be management-led, or is it going to be board-led? Will it be led by a committee of the board? And if so, what committee? So figure that out. Also, think about timing. Is there a particular annual meeting or members meeting coming up that you'd really like to take all of these documents to? And if so, then, kind of work your way backwards to figure out, well, when do we have to take it to the board? And, do we need to take drafts to the board before we take final copies, which you may, depending on how extensive your revisions are. And on that topic, think about what documents you will need to effect this. You're going to need something to amend your letters patent, and you're going to need something to amend potentially as well your bylaws. Will you just produce those amending documents, or will you produce term sheets, summaries of the key changes, or perhaps a comparative chart? Will documents like that be helpful in your process, both for getting board approval and for instructing your lawyers in drafting? So think about the types of documents you'll need. Let me say that if you're going to be making extensive revisions, I really do recommend that you put together some kind of term sheet or comparative chart and have that approved by your board before you go to the trouble of creating the new definitive documents. We can go to the next slide, please. So once you've figured out who's going to be involved in this, then think about the documents that you need to assemble for this process. You need your letters of patent and any amendments to those letters of patent. You need your bylaws and any amendments to the bylaws. If you have terms of reference for board committees or terms of reference for offices, positions, or other documents that describe your officers and their positions, gather those as well. Good to have a list of your directors and members. It's good to have a copy of the Act and the regulations, and we suggest you have a comprehensive summary of the new Act and the regulations. And as I say, Fasken has produced one of those, so that's a good document to have at the ready. And finally, you'll need to have a copy of your last year's financial statements. And in a minute, you'll hear why. We go to the next slide, please. So I'm just going to talk now about amending your letters patent. And let's talk about nomenclature first. So all the companies that are not-for-profits or non-share capital corporations that are incorporated under the laws of Ontario at this moment were created either by a special statute, and I'm not going to talk too much about those, but most were created by letters patent. Now that term, letters patent, is really, really old. I was rewatching The Tudors this summer with my daughter, and Henry VIII was referring to a company that was incorporated by letters patent. Okay, so we know that that term goes back, well over 500 years. So that is the term, though, that we've had until recently. And every time you amended your letters patent, you did it through a document that had that word in it. So we had supplementary letters patent to amend letters patent. We had letters patent of amalgamation to amalgamate entities, or letters patent of continuance to change the jurisdiction for one of these companies. Going forward, we have new terminology. And I'd like to tell you that it's really modern, but as I think about it, I think even the word articles of incorporation, it's newer, but even that isn't the most contemporary term. But anyway, that's what we've got now. So to incorporate a company, you're going to have articles of incorporation. And then every time you change those, you're going to have a different type of article. So you may have articles of amendment, or articles of amalgamation, or articles of continuance. Now, in the old days, to amend any of those letters patent, you needed a special resolution, a resolution approved by a majority of the directors voting on it, and a resolution approved by 2/3 of the members voting on it. Under the Act, going forward, to amend the letters patent, you need a special resolution approved by 2/3 of the members voting on it. It doesn't actually refer to the directors, but I think that you shouldn't feel that this is a huge relief. It would be very improper, I think, for the board to present an amendment to the articles to the members without it first having been approved by the board. So in reality, you'll still need a board resolution if this is an amendment that is being instigated by the board. Laurie's going to talk to you about ways to pass special resolutions that are not instigated by the board. Historically, when you submitted those letters of patent or any variation of them, it was up to the government as to whether or not they would issue them. And they could decide for public policy reasons not to issue them. But going forward under the new act, when you submit those documents, as long as they are properly completed, you will have a right to be incorporated and the articles will be issued. There are new rules for the public guardian and trustee as it relates to these articles, and I'm going to get to that in a minute. Next slide, please. So when you are completing your application for articles of incorporation or articles of amendment, there are some differences that I just want to bring to your attention. So the first is that at this time, every existing corporation and every new company to be formed under the laws of Ontario has something called a company key. It's an alphanumeric code, a series of numbers and letters that will be given to each company. And you're going to need these going forward when you are filing any articles of amendment or anything to amend your existing articles. There's an exception to that. If you have your articles filed by certain listed service providers, you don't need the company key. But if your lawyers are filing these documents or you're doing them yourself, you will need this company key. So your lawyers can request this company key for you, or you can go onto an Ontario government website and you can request your company key. It will be mailed to you by regular old-fashioned snail mail to your registered office address. This is an anti-fraud measure because, unfortunately, if you can imagine, some bad actors have historically filed articles of amendment for companies for which they had no authority whatsoever. So this is a measure to ensure that amendments going forward are filed by appropriately authorized people. Going forward, you'll also have to have a company email address in your articles. So think about, whether that's your corporate secretary or your CEO, your VP finance, whoever it is. If you're a board without any employees, perhaps it's the chair, but think about it carefully because, it will be some effort to change that company email address, but that will be the email address by which various documents will be forwarded to you from company's branch going forward. You're going to have an opportunity going forward, which is great, to put right on the articles what day you want them to come into effect. And so this will be very helpful because sometimes, particularly for amalgamations, we're very particular about the day we want them to come into effect. You'll have to sign the documents as always, indicating that they've been properly authorized. But now there's going to be a big warning there telling you that, there are sanctions for improperly submitting these documents. You'll have an opportunity, as always, when you incorporate or change your name to indicate what the name will be. But now it's going to be very clear based on boxes you check, particularly where you have an English name and a French name, whether these names are to appear together or can appear separately. This was a really gray area before, so it's nice that this is being clarified. When you incorporate, you'll have to indicate whether you will have a board with a fixed number of directors or whether there will be an ability to have a variable number between a minimum and a maximum. Victoria's going to talk to you more about that. Also, when you incorporate going forward now, you have to indicate your North American Industry Classification System code. So this is a very long list of industries that has been created by Statistics Canada. And you'll have to go into this website and identify, whether you're a healthcare entity or an animal shelter or a restaurant, whatever you are, and you'll have to put that on your document. I've had to do it for 2 clients so far. I have to say it's not as easy as it sounds. So allow yourself some time to find where you exist on this long list. And finally, when you file the documents, you'll be asked whether the corporation is a charity. And if you are, and you're amending your documents, it's going to ask you whether or not you have permission from the public guardian trustee not to use the after acquired property clause. And I'll tell you a bit about that in a minute. So we can go to the next slide, please. So as I say, there's new provisions for the public guardian and trustee going forward, and that is because it has an entirely different role. It's really not going to be as actively involved in the process of incorporations or amendments of incorporating documents. In the past, if you were a charity, you couldn't incorporate or amend your letters patent without the approval of the PGT. So going forward, as long as you are not looking for an exception from this requirement to include an after acquired property clause, you will not need the consent of the public guardian trustee to amend your articles. Historically, you always had to submit to the public guardian and trustee, if you're a charity, copies of your articles and lists of your directors and their street and mailing address. Going forward, Service Ontario will look after all of that. You won't have to do that. Historically, we had to provide 3 years worth of financial statements every time we filed articles of amendment, and we won't have to do that at all anymore. Next slide, please. So I keep referring to this after acquired property clause. And once again, I think that this is the wrong word for this clause. It pertains not just to property that is acquired at a later point, but it also applies to property that is acquired at a prior point. This is the clause right here. And what it's saying is that any funds that a charity received before a certain date must be used for the purposes the charity had before that date. And any funds the charity receives after that certain date, pursuant to a document that was written prior to that date, also must be used for that prior purpose. Now, when I say other document, I'm talking about a will or a deed of gift or some agreement like that. And the thinking here is this: if you incorporate your corporation as a charity for the purpose of running an animal shelter, for example, and you receive undesignated gifts, you have a fundraiser and you get some money and people are just giving you the money, there's no designation. It's assumed that all the money that you receive through that fundraiser, that those funds will be used for the animal shelter. If you then change your articles, you decide animals are looked after well enough. Now we're going to look after the environment. You're going to change your purposes. Well, it makes sense that all the money you received before you changed your purposes would continue to be used for animal shelter purposes. And again, if you received money under a will, but the will was written while your objects were to run an animal shelter, similarly, those funds should be used for that purpose. And we can go to the next slide, please. So hopefully that's advancing for you. The next slide talks about amending bylaws. There's a decision that you're going to have to make where you are amending your bylaws, and that is whether you are going to adopt a standard bylaw that has been created by the government, or whether you are going to create a brand new tailor-made bylaw. So the government's bylaw is a short bylaw. It's only about, I think, maybe 8 pages long. And all the government has put in the standard bylaw are the terms that are variable in the statute. Things like, how many directors you will have, how many classes of members you have, who your funds will be distributed to on dissolution, that sort of thing. I'm exaggerating, but it's really the things that are variable that are going to go into that bylaw. Now, if you have a bylaw that has been prepared by Fasken's or probably any other law firm up until now, your bylaw for a Nonshare capital company will be much longer than that. It will have all of those tailor-made things, but it will also have other provisions, which, yes, they are in the Act, but we think people need to have them at the ready, that you need to be able to look at your bylaw and easily see them there. Things about how much notice to give for members' meetings, who's invited to attend, that sort of thing. So consider that. You may be happy to have the very short government prepared bylaw, but if not, and I would suggest not, I would suggest you look for a longer bylaw, particularly at this time. There are a lot of new provisions in the new statute, and particularly until you get used to them, I think it'll be good for you to have them in your bylaws. All right, so once you pick out which route you're going, the standard or something tailor-made, then you'll get it all prepared based on likely that term sheet or that comparative document that we spoke about earlier. And then the question is, when will it come into effect? So under the new Act, it can come into effect as soon as the board approves it, and it will continue to be in effect until your next meeting of members. And so long as at that meeting, your members confirm it, then it will continue to be in effect. But if the members don't confirm it, then it will no longer be in effect. You won't be able to make any changes of that nature in the future without the approval of the members. Now you can see on this slide, I use the word generally. I've said that generally these will come into effect at that time. There are some exceptions. If your bylaw has anything to do with amending the way that members receive notices of meetings, the way memberships can be transferred, or the way members can vote at a meeting, those provisions can only come into effect when the members actually approve them. Okay, we can go to the next slide, please. So finally, I'm just going to speak to you about the different categorizations of companies under this Act. In the Federal Not-for-Profit Corporations Act, we have soliciting corporations and non-soliciting corporations. Under the Provincial Act, we have public benefit corporations and non-public benefit corporations. So we can go to the next slide, please. So a public benefit corporation is comprised of any non-share capital corporation under this statute that has been incorporated for a charitable purpose. And this means an entity that has charitable status, but it also includes an entity that has charitable objects but hasn't yet received charitable status. Public benefit corporations also include entities that are not charities. They aren't going to be, they don't have charitable objects, they just have regular not-for-profit objects. But where they have received more than $10,000 in funds from third parties, from regular donors or from government, then they will be deemed to be a public benefit corporation. If they receive funds from their own members or directors or officers, those funds don't count in calculating this $10,000 amount. All other companies are non-public benefit corporations. Now, a lot of things, there aren't too many, but there are probably about 6 things that are affected by this status. And many of these things are triggered at an annual meeting. And so the determination about whether or not you are a public benefit corporation will be made at an annual meeting, having regard to the prior financial year. So let's go to the next slide, please. So this is just an example. So let's say a company has a financial year end of December 31st, and it's only on December 10th of that year that it receives that final dollar that puts it over the $10,000 limit. It at that point would appear to be a public benefit corporation, but it's very awkward if its status changed at that point. So instead, you go to the next annual meeting of this company, which is in April of the following year. I put it as April 15th. At that meeting, they would look back, as they prepare for that meeting, they would look back to their prior year and realize that they are a public benefit corporation. And that will mean that some things at their annual meeting have to be done a little differently. We can go to the next slide, please. So it's going to affect the level of financial review. Just to remind you, it is an absolute basic right of members to be able to receive audited financial statements of a corporation of which they are a member. That is a fundamental and basic right. But it is recognized that it costs a lot of money to have audited financial statements prepared. And sometimes members are perfectly willing to waive that requirement. And so the Act contemplates this notion of an extraordinary resolution that is approved by 80% of the members entitled to vote. And if those members pass an extraordinary resolution, that it is possible to reduce the level of financial review for a corporation. If you're not a public benefit corporation and your revenues are less than $500,000, you may not need to have any kind of financial review if an extraordinary resolution is passed to that effect. If your revenues are over $500,000, then again, if the resolution is passed, you could have simply a review engagement, which is a type of review by an accountant or auditor, but it is not the same level as an audit. If you are a public benefit corporation, then again, if your revenues are less than $100,000, if everyone approves or if 80% of the members approve, you may not need any financial review at all. If they're over $500,000, you definitely have to have a full audit. And if the number is in between, then it could be a review engagement. And before we go further, I just want to say that these numbers that I have been talking about, both that $10,000 number that triggers the public benefit corporation test, and these numbers here, these are set out in the regulations to the Act. So these are the current numbers. They could change in the future. Go to the next slide, please. So another thing you're going to do at the annual meeting, in addition to appointing an auditor or an accountant or waiving that requirement, another thing you're going to do is appoint the directors. Victoria is going to talk to you about the fact that under this Act, every corporation has to have at least 3 directors. But if you're a public benefit corporation, then no more than 1/3 of those directors can be employees of the corporation or its affiliates. Laurie's going to talk to you about members' dissent rights, and you'll see that they are not available to public benefit corporations. And finally, go to the next slide, please. There's a difference in treatment for how the funds of the corporation are dealt with on the company's dissolution or when a member leaves the corporation. So we'll start with the second one first. Under the new Act, a public benefit corporation must provide for its assets on dissolution to be distributed to a charity or a non-charity with similar purposes or to a government agency. Now, if you're a charity, you will have to say that they are going to go to a charity or a governmental organization. You won't be able to get them to a not-for-profit. But you can see the important point here is you can't distribute them to the members. So if you have excess funds, they cannot be distributed to the members. And so it makes sense, therefore, that when a member leaves, they're not entitled to fair market value for their membership interest. And on the flip side, for non-public benefit corporations, on dissolution, those assets can indeed go to the members unless your articles say otherwise. And so similarly, if your articles don't prohibit that, it would be possible to distribute funds to a member when they cease to be a member. Now, for all of these tests about whether or not the corporation is a public benefit corporation, you always look back 1 year just to look at the financial statements of the prior year. But for this question here about a dissolution of a corporation, you actually have to look back 3 years. So if the company was a public benefit corporation in the 3 years prior to the dissolution, that will dictate whether or not the members are entitled to receive funds on the dissolution. Next slide, please. Okay, so that ends my presentation. Again, happy to take any questions about that at the end of our talk. I'm going to turn the microphone over now to Laurie Turner, who's going to speak to you about members and members' rights.
Thank you, Lynn. Advance to the next slide, thanks. So prior to jumping into the rights that are afforded to members under the new Act, I'm going to provide a brief overview of the distinction between members and directors. And while this distinction might be very clear to some of you, we found, whether it be from reviewing clients' current bylaws or from discussions with their board, that this distinction is first, not always clear, and second, not properly deserved. And this is particularly the case where individuals who serve as the directors also serve as the members of the corporation. I've used the word distinction numerous times already, and it's intentional, and it's intended to emphasize that the Act prescribes distinct roles for directors and members, and it's important that the corporation respect these roles. So at a very high level, members of a not-for-profit corporation are often compared to shareholders of a for-profit company, and that they have the right first to elect the board of directors, generally speaking, and second, the right to vote on fundamental corporate matters, such as a sale of all or substantially all of the assets of the corporation. However, one important difference between members and shareholders is that, unlike shareholders who have an ownership interest in the corporation expressed by way of their ownership of shares, members don't actually own a not-for-profit corporation. Directors, on the other hand, are responsible for the management of the corporation's activities and affairs, and they have fiduciary obligations to the corporation, such as a duty to act in the best interests of the corporation, whereas members do not have such fiduciary obligations. And finally, members of a not-for-profit corporation are not responsible for its debts and obligations, unlike, for example, members of an unincorporated association. And directors, on the other hand, have personal liability under the Act, but only in limited circumstances. Next slide, please. With respect to the election and removal of directors under the Act, generally speaking, at each annual meeting, the members will elect the number of directors that is required to fill any vacancies on the board. There are a few exceptions to the right of members to elect directors, however, and one of these exceptions arises when a vacancy occurs on the board midway through a director's term. In that case, the directors may fill the vacancy subject to certain exceptions, which are listed on this slide. And these exceptions include, for example, where the vacancy arises from the member's removal of a director at a meeting. And in that case, the members have the first right to replace the director at the meeting at which the removal of the previous director occurred. Failing that, then the directors have the right to fill the vacancy. Also, one of the exceptions arises where a membership group or class has an exclusive right to elect the director whose vacancy is being filled. In that case, only the members of that group or class will have the right to fill the vacancy. And finally, and perhaps most importantly, where the corporation's bylaws provide otherwise. So this means that if your organization wants to restrict the right of the board to fill vacancies on the board, then you must explicitly set forth those restrictions in your bylaws. So just as they have the right to elect directors, members generally have the right to remove directors. Under ANCA, generally speaking, the members can remove a director by way of an ordinary resolution. And this is distinct from the Corporations Act, which required at least 2/3 of the members to approve the removal of a director. As a side note, you may have caught that I did not refer to that 2/3 vote as a special resolution. So the vote under the new Act is a special resolution. And this is because under the Corporations Act, the term special resolution meant a resolution that was first passed by the directors and then second confirmed by a vote of at least 2/3 of the members. I bring this up because under ANCA, the term special resolution has a different meaning, and it instead means a resolution of 2/3 vote of the members, and it requires no director's approval. In terms of the exceptions to the rights of members to remove directors, members do not have the right to remove a director who is serving as a director on account of the director's office, and these are commonly referred to as ex officio directors. So, for example, if your corporation's bylaws prescribe that the president of an associated organization will be a member of the board, then the members would not be entitled to remove that director from the board using an ordinary resolution. Next slide, please. So Lynne spoke a little bit earlier about the requirements and thresholds that apply to audits and review engagements. And as to the members' rights vis-a-vis auditors and a person conducting a review engagement, first, members have the right to appoint an auditor or a person conducting the review engagement and also to set the remuneration. Also, members have a right to remove these people by way of an ordinary vote, which again is distinct from the Corporations Act, which required a 2/3 vote of the members, with the exception that the members do not have the right to review or to, they don't have the right to, they don't have the right to remove an auditor who's been appointed by the court. Notably, the default under ANCA is that the directors may fill a vacancy of an auditor or person who is conducting a review engagement. So this means that if your organization wishes to keep that right as a right exclusive to the members, then you must specifically provide for that in your bylaws. Next slide, please. So So with respect to members' meetings, a few significant changes under ONCA. One distinction that I will point out is the distinction in nomenclature. So whereas under the Corporations Act, the annual meetings of members were referred to as a general meeting, or AGM, the term given to these meetings by ONCA is annual meeting. But more significantly, there are differences between the notice requirements for members' meetings under ONCA versus the Corporations Act. So first, while the default and minimum notice period under ONCA remains at 10 days, ONCA imposes a maximum notice period. So this means that notice of a members' meeting cannot be given more than 4 days before the meeting is to occur. Also notably, unlike the Corporations Act, ONCA requires that where special business is going to be transacted at a meeting, the notice of the meeting must first state the nature of the business in a sufficient amount of detail that will permit the members to form a reasoned judgment on the business. And second, the notice must also include the text of any special resolution that will be submitted to the meeting in respect of the special business. So you may be questioning when these notice requirements are triggered in respect to special business and what exactly is meant by special business. So the term is quite broad. ONCA specifically provides that all business to be addressed at a members' meeting is special business, except the defined list of actions. So that includes consideration of the financial statements, not special business. Consideration of audit or review engagement report is also not special business. And the following are also not special business, but everything else is going to be special business. So an extraordinary resolution to have a review engagement instead of an audit, the election of the directors is regular business, and the reappointment of an incumbent auditor or person conducting the review engagement. So as I said, all other matters are special business, in which case these requirements with respect to notice must be followed by the corporation. So it's clear that in many circumstances, on a going forward basis, the notice that your organizations provide will be required to include details of the special business and the text of any resolution that will be submitted to the members in respect of that business. So that's just something to be aware of in terms of planning for the notice and the time that you'll need to prepare that notice in advance of the meeting. Next slide, please. So with respect to methods for voting, significantly, unlike under the Corporations Act, ONCA provides that members only have the right to vote by proxy if proxy voting is permitted by the corporation's articles or the bylaws. And this is distinct from the Corporations Act, under which members had the right to vote by proxy, full stop. So this means that if your organization has used proxy voting in the past and wishes to continue to do so, or wants to use proxy voting on a going forward basis, then you will need to specifically permit proxy voting and include it in your articles or bylaws. Also interesting is that ONCA, distinct from other federal and provincial legislation that's applicable to corporations, allows the articles or bylaws of a corporation to require that a proxy holder be a member of the corporation. So that means an individual cannot appoint a proxy holder that's a friend but isn't a member of the corporation. And while this may seem not too contentious, in the case that a member doesn't know or doesn't have a relationship with other members of the corporation, they may be unable or unwilling to have another member act as their proxy holder, something that will change on a going forward basis. So in addition to or instead of proxy voting, corporations may also provide in their bylaws for voting by mail or by telephonic or electronic means. However, while telephonic or electronic means for voting were included in the Corporations Act, ONCA introduces new requirements that apply to the use of these means of voting. So first, in order to use telephonic or electronic means for voting, the means must enable the corporation to verify a vote as coming from a member who is entitled to vote on that matter. And second, the means must not permit the corporation to know how a member voted. Rest assured that the special rules for COVID that were adopted under the Corporations Act regarding the use of virtual meetings and related voting procedures continue to apply under ONCA, and it's currently the case that these special rules will continue in force until September 2022. Next slide, please. So this exact slide was included in our slide deck for our original ONCA presentation many years ago. At that time, we focused on a significant and distinct set of rules under ONCA that gave non-voting members the right to vote in certain circumstances. And these rights were similar to the rights of non-voting members under the federal not-for-profit legislation, the Canada Not-for-Profit Corporations Act. Next slide. However, recently, ONCA was amended to remove these rights of non-voting members. Next slide, please. So what this means is that under the current version of ONCA, non-voting members are just that, non-voting. And this is welcome news to many organizations who were looking to reorganize their membership structure, such as by engaging in a membership collapse in response to the right of non-voting members to vote under the previous version of ONCA. Also, unlike the previous version of ONCA and the Canada Not-for-Profit Corporations Act, ONCA does not prescribe any class voting rights in respect to fundamental changes, which we'll discuss a little bit later. While members still have a right to approve fundamental changes by way of a special resolution, ONCA does not afford any separate right to any class or group to approve such matters. Next slide, please. So moving to inspection rights. So this slide ties into the next presentation on members' remedies, and that it speaks to the right of members to inspect certain of the corporation's documents. So under ONCA, members have the right to examine and take extracts of various records of the corporation. However, I need to make a correction here. The inspection rights actually don't apply to minutes of directors' meetings and past board resolutions, but otherwise the right is quite broad to include minutes of past members' meetings, past members' resolutions, the register of directors, officers, and members, provided that there are a few things to note. First, members may be required to pay a reasonable fee to take extracts of documents. However, with respect to the articles and bylaws, the corporation is not permitted to charge any sort of fee to the members for the first time that they receive articles or bylaws or any amendments thereto. Second, the examination has to occur during the corporation's regular business hours. So that's probably good news for corporations. They don't have to open up their doors on the weekend if that's not their regular business hours in order to permit this inspection to occur. And finally, with respect to the members register, it's subject to additional restrictions. So this means that if you receive a request for the members register, it's important that you refer to the specific rules in ONCA that apply to the examination of such records. I'm not going to go into details, but that's an important thing to note. Next slide, please. So with respect to inspection rights, in terms of inspection rights of financial information, this slide includes an overview of inspection rights as they relate to financial information of the corporation. So while the corporation is required to put forth the financial information listed in the middle left-hand cell, so being the financial statements, the report of the auditor or person who conducted a review engagement, and any further information respecting the financial position of the corporation and the results of the corporation's operations that's required by the articles or the bylaws to be submitted to the members. So this information, as I said, must be presented at each annual meeting. However, members are also entitled under ONCA to request a copy of these documents be sent to them prior to the meeting. But in that case, they have to submit that request not less than 5 days prior to the meeting. I also note that there's no automatic requirement for the corporation to send out this information to members, and that a corporation is only required to provide this information to members in advance of an annual meeting where a member makes a specific request for that information. And then finally, on this slide, we won't get into this too much, but the rights under ONCA also afford members with the ability to obtain a copy of the financial statements of each of the subsidiaries, in each case where the accounts are consolidated on the financial statements of the corporation. So this means that if your corporation is consolidating its financial statements with other entities, then members have the right to those consolidated financial statements, which includes the financial information of your subsidiaries or any other entities that are included on those consolidated statements. And that information is available on request. Next slide, please. So moving to requisitioning of meetings. This is another new right of members under ONCA, and again, it ties into the next presentation, which is related to members' remedies. So ONCA allows members holding either 10% of the votes to be cast at a meeting, which is the default number, or a lower percentage set in the bylaws to requisition a meeting of the director, or sorry, to requisition the directors to call a meeting of members. And so while the Act is very detailed in terms of the requirements and the process that applies to the requisitioning of meetings, in summary, and without going into too much detail regarding timing, a member must send the requisition to the directors and to the corporation with the details of the business that will be the subject of the requisitions meeting. So essentially they have to send a notice to the directors and the corporation saying, I want a meeting to be called and it's for this purpose. In response to that requisition, the directors must call the requisition meeting within 21 days. And if the directors don't call the meeting within that time period, then any member who signed the requisition for the meeting may call the meeting directly. So the Act does recognize some exceptions to the requirement for the directors to call a member's meeting in response to a requisition. So of course, where the requisition does not meet the requirements of the Act, so for example, where it's not submitted 60 days or more in advance of the meeting, then the board doesn't have to call the meeting in response to requisition. But also where it appears to the board that the primary purpose of the meeting that's being requisitioned is to either enforce a personal claim or to redress a personal grievance, they don't have to call the meeting. Also, there's no obligation for the directors to call a meeting in response to a requisition where the business that's proposed doesn't relate in any significant way to the activities or affairs of the corporation. Next slide, please. So as I stated in the previous two slides or previous two matters, those were some of the remedies that were available under the new Act, but kind of fell into the category of members' rights and members' remedies. So we dealt with them under that presentation. But this presentation is going to be also dealing with a few other members' remedies and also the right of members to make proposals. Next slide, please. So one of the intentions of the new Act was to improve the rights of members of not-for-profit corporations, for example, by increasing transparency and also providing additional remedies to members where the corporation or the directors, for example, aren't complying with the corporation's bylaws or articles or the Act itself. So whereas members' remedies under the Corporations Act were limited and were typically left to be decided by the corporation through its bylaws, members' rights and remedies are specifically entrenched and also expanded in ONCA. Slide, please. So in terms of the remedies available to members under ONCA, the remedies that are listed on this slide being the removal of directors by ordinary resolution, increased access to financial information of the corporation, and a right to requisition a meeting, were addressed in my last presentation. So those won't be the subject of this presentation. Next slide, please. This presentation will instead focus on the other remedies available to members under ONCA, including the right for members to make proposals, dissent rights in respect of prescribed fundamental changes, and also the various rights of members to apply to a court for specified orders. The availability of these remedies is restricted in some cases to particular corporations. The dissent right, for example, is only available to non-public benefit corporations. So, for example, is not available to members of a charity. And in addition, the right of members to apply for a court order to commence a derivative action is not available to members of a religious corporation. Next slide, please. So I said in a nutshell here, because if any of you have looked at ONCA and seen the provisions relating to members' remedies, you'll know that these provisions are extremely complex and even more so lengthy. In the majority of cases where a member or members are going to be relying on these remedies, you will need to seek legal advice likely in order to support you in respect of the applicable remedy. So we're not going to go into too much detail, but we will go into these remedies just at a high level. Next slide, please. So under ONCA, any member who has the right to vote at a members' meeting may, number one, give notice to the corporation of any matter that the member wishes to raise at the meeting, referred to as a proposal, and also to discuss any such matter at the meeting when it's held. Members must submit a proposal at least 60 days before a meeting in order for the corporation's obligations to include the proposal in the notice of meeting. Proposals may address various matters, including, notably, nominations for directors, but only where the proposal is signed by at least 5% of members or a lower percentage of members set forth in the bylaw of the specific class or group entitled to elect the director. And if you have only one membership class or one membership group, it will just be 5% or the lower percentage set by your bylaws. Next slide. Continuing with respect to make a proposal, like the right to requisition a meeting, the member's right to make a proposal under ONCA and to discuss the matter at a member's meeting is subject to certain exceptions. So, for example, a corporation is not required to comply with its obligations in respect to proposals where the proposal appears to be for a primary purpose of redressing a personal claim, where the proposal doesn't relate in any significant way to the activities or affairs of the corporation. And also, interestingly, the Act specifically provides that where the member who has submitted a proposal in the last 2 years, and that proposal was included in a notice of members meeting, but then the member failed to present the proposal at the meeting, then that member is barred for presenting a proposal for 2 years. Also, the Act specifically provides that where a proposal that was substantially the same as the current proposal was presented to and then rejected by the membership in the last 2 years, then the corporation does not need to include this proposal. Moving on to the next slide, please. So as noted earlier, members are entitled to approve by way of special resolution certain fundamental changes. Where the corporation provides notice to members of proposed fundamental change, generally speaking, members who have the right to vote on the proposal also has a right to dissent. And again, this is subject to exceptions. So the most notable of which is that this right of dissent and the associated remedies doesn't apply to members of public benefit corporations. The process for dissent is prescribed by the Act and is very detailed. But in summary, where a member provides an objection to a fundamental change, and then the fundamental change is ultimately approved by the members, the corporation has an obligation to notify any members who submitted an objection to such change, and also to provide the members with notice of the process to be followed by the member with respect to dissent. Following the member's receipt of that notice from the corporation, a member is then entitled to submit a demand to the corporation to be paid their fair value of their membership interest. And given this payment to the member, it's a bit more clear why this right of dissent is not available to members of public benefit corporations such as charities. In response to that demand for payment, the board then generally has the obligation to determine the fair value of the membership interest and to present that value together with the method by which the value was determined to the member. However, there are cases where the board is not obligated to determine and offer a fair value for the membership, including where the payment of the membership value would cause the corporation to be unable to pay its liabilities. If the corporation is required and doesn't provide an offer to the member, or if the member rejects the value that was set by the board, then an order can be made to the court to determine the value. And that process might include a court appointing an appraiser to determine the membership value. And not surprisingly, subject to limited exceptions, a member's delivery of a notice of demand for payment of the member's membership interest triggers the termination of that member's membership interest in the corporation. Next slide, please. Oh, sorry, next slide as well. Thank you. So with respect to compliance orders, again, at a very high level, members and prescribed former members may apply to the court to make an order directing the corporation generally, or one of the listed persons, such as a director, employer, agent of the corporation, to either comply with the Act or the corporation's bylaws or articles, or to make an order to restrain such person from acting in breach of any of the Act or its regulations or the corporation's articles or bylaws. And the corporation may make any order that it sees fit. Next slide, please. Moving on to derivative actions, another remedy available to members. So members and prescribed former members, being members or individuals who are members of the corporation within the last 2 years, together with other complainants, may apply to the court to make an order granting the member leave to first bring an action in the name of and on behalf of the corporation or any of the corporation's subsidiaries, or to intervene in an action where the corporation or any of its subsidiaries is a party for the purposes of prosecuting, defending, or continuing the action on the corporation's behalf. So without the above rights, no action could be brought in the corporation, since corporations are legal persons that are distinct from the natural persons that comprise them. But the court is only able to make either of the above orders where the prescribed conditions are met, including where the corporation is not a religious corporation. So members of religious corporations do not have these remedies available to them. And again, the court can make any order that it thinks is fit in the circumstances. Next slide, please. Moving on to investigative orders. Members also may apply to the court to direct an investigation of the corporation or its affiliates. And the court has broad powers in connection with those investigations, including to appoint an inspector, to require a person to produce documents, and to authorize an inspector to enter a place. However, where that place is a dwelling, like a person's house, additional requirements will apply, and the ability of the court to inspect those premises is more limited. And notably, the court may only direct an investigation of this nature where it determines that one of the prescribed actions or omissions has occurred. And while the list of actions and omissions is lengthy, it includes, for example, where the corporation or its affiliate activities appear to be or have been carried on with the intent to defraud people, and most significantly for the current purposes, where the corporation or one of its affiliates or the directors of the corporation engage in conduct that is oppressive or is unfairly prejudicial to the interests of the member or unfairly disregards the interests of a member. Moving to my final slide, and remedies available to members. So under ONCA, a court may make an order winding up a corporation in prescribed circumstances, including where the powers of the directors of the corporation have been exercised in a way that is unfairly prejudicial or unfairly disregards the interests of members, and also where the members have authorized, by way of a special resolution, an application to be made to the court to wind up the corporation. So it's therefore clear that the members may themselves, without the involvement of the directors, make an order to the court to wind up the corporation where they've resolved to do so by way of a special resolution. And in response to an application to wind up the corporation, the court has broad discretion. So they can either grant the order to wind up to the corporation, they could reject the order to wind up the corporation, or reject the request to wind up the corporation, or they could take another action, such as including to appoint a liquidator to the corporation. And finally, if a corporation is wound up by way of court order, the court then may make an order dissolving the corporation in response to any application of a liquidator or other interested persons. Next slide. Great. So next, Victoria Mitrova will be presenting on directors and officers.
Thank you so much for that introduction, Laurie. Today I'm going to be discussing some of the notable changes from the ONCA that relate to directors and officers. And as you'll see on the next slide, which we can move to now, I'll be covering 6 broad ideas in terms of what the ONCA provides for. And these will touch upon who can sit on the board of directors, how long they can act as directors, as well as what directors and officers should keep in mind when performing their duties. You can go to the next slide. Now, I will probably be repeating some information that Lynne and Laurie have already touched upon in their presentation, so hopefully I don't bore you too much, but sometimes repeating information, at least for me, helps it stick in my memory. So, as Lynne already mentioned, under the ONCA, not-profit corporations are still required to have a minimum of 3 directors, but these directors no longer need to be members of the corporation. And specifically for public benefit corporations, no more than 1/3 of the directors can be employees of either the corporation or any of its affiliates. Ex officio directors are permitted under the ONCA. These are individuals who are directors by virtue of their office. So for instance, if your bylaws provide that the CEO of a corporation is a director, that individual is an ex officio director. The articles of the corporation can also provide for a range in the number of directors. For instance, it can say that it can be anywhere from 3 to 7 directors. And pre-ONCA, if a corporation wanted to fix the number of directors, the members would have to pass a special resolution fixing that number, and would have to pass a similar special resolution every time they wanted to fix that number. Now, although that mechanism is still available, the ONCA also provides an alternative. If the members pass a special resolution, they can give the directors the power to fix the number of directors within that range set in the articles. Next slide. Now, as Laurie discussed earlier, directors are elected, and you can ignore the wrong acronym here, but at annual meetings via ordinary resolutions of the members. And directors can be elected for a term of up to 4 years. Now, if the term is not set when the directors are elected, then their term will cease at the end of the next annual meeting. There is no limit on the number of terms that directors can serve under the ONCA, so theoretically, you could be re-elected indefinitely. Staggered terms are also permitted. So this means that directors do not all need to serve the same length of time when they are elected. And although most directors are likely to be elected through annual meetings, there is an opportunity for directors to appoint additional directors between annual meetings, with the caveats that the number appointed cannot exceed 1/3 of the total number of directors elected at the prior annual meeting. Additionally, those appointed directors will serve until the end of the next annual meeting, so their term will not exceed the 1 year between until the next annual meeting. Pardon me. Next slide. Now, a new requirement under the ONCA is that directors have to provide written consent to take their office within 10 days of being elected or appointed as a director. Now, you can provide this consent outside of the 10-day period, and written consent is not required for directors who are re-elected or reappointed and where there is no break in their term. So, for instance, if someone is serving as a director and is re-elected as a director and they continue on in their term, then they don't need to provide that written consent. Laurie also touched upon this, but again, directors can be removed by an ordinary resolution of the members, and this is for all directors other than ex officio directors. But please keep in mind that if a director is elected by a specific group or class of members, they can only be removed by an ordinary resolution of that specific class or group of members. Next slide. Now, in addition to setting out who can serve on the board and for how long they can serve on the board, the ONCA outlines considerations that directors and officers should have when performing their duty. And one of these is what standard directors and officers need to meet when exercising these duties. It sets out specifically an objective standard of care. This isn't anything new, this was the case beforehand, but as a good refresher, an objective standard of care means that directors and officers have to exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. Directors and officers are also required to act honestly and in good faith with the view to the best interests of the corporation when performing their duty. And this is important for two reasons. First, the ONCA permits corporations to indemnify directors and officers if they act honestly and in good faith with a view to the best interests of the corporation when exercising their duties. And if we move to the next slide, you'll also see that the ONCA provides for a reasonable diligence defense for directors. And so there are certain provisions in the ONCA which state that directors may be held liable for some decisions that they make. But if directors can establish that they exercise the care, diligence, and skill of a reasonably prudent person in comparable circumstances, then they will not be deemed to be liable for those specific decisions. As part of a reasonable diligence defense, directors can rely upon reports they receive from professionals, other officers or employees of the corporation, as well as financial statement reports. Next slide. And as I'm talking about the theme of potential liability and defenses to it, another topic that arises that you should be aware of is that the ONCA now establishes as what I'll refer to as a director's deemed assent. So before the ONCA, directors would, of course, all the time need to make decisions upon certain matters and resolutions and would vote upon those at meetings. And one of the ways, if there is ever a possible liability attached to a decision to determine whether a director should be held liable, is to see how that director voted on that resolution or matter. And directors would be able to abstain from votes at meetings, or if they were absent, could also not have their vote registered. But this is no longer the case under the ONCA. Now, if a director is present at a meeting, they will be deemed to have consented to a motion unless their dissent is registered, either whether it's entered into the minutes or if the director gives their dissent during or immediately after the meeting. Similarly, if you are not present at a meeting, a director can still be deemed to have consented to a motion if their dissent is not recorded within 7 days of becoming aware of a resolution passing. And so again, this is key to note because essentially you will now be forced to make a decision. And if you don't record that dissent, you will be deemed to have consented to a motion. And that consent may have implications if something turns out to arise from that decision or that resolution that is passed. Next slide. As we're on the topic of exercising duties and being mindful of what decisions directors make, I'm also going to turn to what the ONCA says about conflicts of interest. Now, this isn't a new topic. Directors had to face this issue before, but the ONCA broadens this idea of a conflict of interest, including who it applies to. Now, both directors and officers are required to report conflict of interest. And additionally, it also expands what is considered a conflict of interest. So now a director or an officer of a not-profit is considered to be in conflict of interest, either if they are a party to a possible contract or transaction, but also when they are the director, officer, or have a material interest in another party that may be dealing with the corporation, either through a contract or a transaction. And so if one of these situations arises, the director or the officer is required to report this conflict of interest to the corporation. When a director is in a conflict of interest, they are not permitted to attend the meeting or the portion of a director's meeting where this matter will be discussed. Directors are also prohibited from voting on a resolution where it addresses a matter in which they are in conflict with. Now, although the ONCA sets out certain quorum requirements, if for any reason one or more directors are conflicted out and the quorum would otherwise not be met, the ONCA provides that the remaining unconflicted directors will constitute quorum for the purpose of voting on that resolution. And if for any reason all of the directors are conflicted out of voting on a certain matter, the ONCA authorizes the members to approve or reject a matter. Next slide. As we're on the topic of conflicts of interest, there are also some specific rules that charities should be aware of, which I want to touch upon briefly. Now, the ONCA permits corporations, directors, to fix remuneration for directors, officers, and employees. So essentially to pay funds to either directors, officers, or employees by virtue of being in their office. Directors, officers, and members can also receive reasonable remuneration or expenses for services they provide to the nonprofit in another capacity. But charities should be aware that this isn't just, these two provisions aren't just simply the case or aren't just easily applicable to charities because, as you may be aware, the directors of charities are not permitted to be paid for the acting in their capacity as directors of that charity, as under the Charities Accounting Act. And while regulations under the Charities Accounting Act permit charities to pay directors or persons connected to directors for services they provide, there are a number of rules and requirements that must be met before such payments can be made. And so, if for the sake of brevity, I'm not going to go over them now, but suffice to say, if you are a charity and you are considering relying on the ONCA provisions in order to compensate a director, please review the Charities Accounting Act, potentially get legal advice, maybe even from us about it before you go ahead. Next slide. And finally, just touching upon the idea of officers, the ONCA provides that directors can designate offices, appoint officers, and specify the duties that officers conduct, as well as delegating certain powers to those officers. And those limitations are provided for in the ONCA. Directors may serve as officers, but don't necessarily need to be, except one exception, which I'll get to in a moment. And an individual can hold more than one office. The only office that the ONCA sets out is that of chair. And under the Act, the directors must appoint from among themselves someone to serve as the chair. And so that was just a brief overview about the provisions relating to directors and officers. It certainly wasn't a full-fledged, overview, but I'm happy to answer questions as we go to the end of our presentation. But before then, I turn to Briana who will be speaking about specific exceptions applicable to public hospitals.
Thank you, Victoria. Good morning, everyone. With regards to the ONCA conflicting with other laws, the ONCA states that entities governed by specific legislation or special acts are still governed by that legislation. So, for example, where a conflict exists between a provision in the ONCA and a provision in the Public Hospitals Act, the Public Hospitals Act will prevail. I'll now draw your attention to 4 conflicts where the Public Hospitals Act takes precedent over the ONCA. So first, the rotation of directors. As Victoria mentioned, the ONCA provides that directors may hold office for a term expiring no later than 4 years after their election. However, the Public Hospitals Act sets out a maximum term of 5 years for directors. Further, a hospital may provide by bylaw for the appointment of life directors, term directors, and honorary directors in recognition of worthy contributions made to the hospital, and the ONCA does not provide for such special directors. Voting by proxy, as Laurie mentioned, although the ONCA allows a member of a corporation to appoint a proxy holder if permitted by the bylaws or articles, the Public Hospitals Act expressly does not allow for this type of voting by a member at any meeting. And lastly, notice. Laurie touched on the fact that the ONCA states notice of members meetings shall be given not less than 10 days and not more than 50 days before the meeting is scheduled. And this notice should be given to each member and the auditor or person appointed to conduct a review engagement. Despite the ONCA, the Public Hospitals Act states that it is not necessary to send written notice of any general or special meeting of the members to each member. It's considered sufficient notice if such meeting is published in a newspaper, circulated in the municipalities where members reside at least once a week for 2 successive weeks preceding the meeting. And I'm now going to turn it over to Lynne for the Q&A. Thank you.
Well, thank you very much, ladies. And we have a number of questions that are coming in. I'm going to kind of try and rotate them through you. A couple of them were for me, so I think maybe I'll start with those. The first question we received had to do with the definition of a public benefit corporation, and you'll remember that I said that that applied where the entity received more than $10,000 of funds from third parties. And the question was, what does funds mean? Does this include fee-for-service revenue? And that's an excellent question. So I was possibly too broad in my words. I think they're correct on the screen. That $10,000 relates to donations or to grants from government. It is not for payment for services. So if you receive services or if you run a gift shop or anything like that, that is not counted in the calculation of the $10,000. Now, under the federal law, which has a similar sort of concept for the definition of soliciting corporations, we were asked quite a number of times whether in looking at that threshold, one would include amounts received as a COVID, during COVID, special funds for relief that were provided during COVID. And our view is that yes, those are included as well. And under the federal act, it has an even greater impact because the status applies for 3 years. Here in Ontario, it only applies for 1 year. So anyway, any kind of government money that is a grant would be included, but funds that you receive for services or for goods sold, those are not included. The next question was, can you comment on the purposes of a corporation that need to be specified in its articles? I believe that an ONCA corporation has natural person powers. Does specifying purposes, especially too narrowly, limit the natural person powers and introduce a risk of ultra-virus actions? So this is a very interesting question. First of all, yes, you will have to put your purposes in your articles of incorporation, and they are called purposes rather than objects. If you are a charity, you are still going to want to be very, very careful about how you draft those purposes, because you will want them to constitute purposes that are charitable law in order that you can obtain charitable status that you seek. If you are a not-for-profit corporation, you don't need to be so precise, but it is my recommendation that you you be careful and that you try to ensure that the activities you are carrying on are consistent with your purposes. So this notion of ultra vires is very old legal principle. And the principle was that if directors authorized a corporation to carry on an activity that wasn't contemplated by its objects, as they were then called, and if liability arose from those activities, then the directors could be personally liable for having approved this ultra vires action. I think if you ask our research lawyers at Fasken's about this now, they will say that there is no longer a concept of ultra vires because under the corporation's statutes, and it's been this case for some time, non-share capital corporations have the power of natural persons. So that's what they would tell you. But I will tell you, my advice is you should act within your purposes or objects. And if you are taking on new activities, I do highly recommend that you do amend them. Notwithstanding the fact that we have natural power purposes, what is the purpose of setting out your purposes in your objects if it isn't with the intention of trying to limit it in some way? So I strongly recommend you live within your purposes or amend your purposes. Laurie, we have a question about whether inspection rights apply to non-voting members.
I believe that they do. I don't. Let me just take a look back at my inspection rights. I believe that the inspection rights do apply to non-voting members because many of the other remedies that are available specifically provide that they're available to members who may vote at the meeting. So for example, with respect to requisitioning a meeting, obviously only members who are voting members or who are entitled to vote at that meeting may requisition the members. But I believe that the right to inspect that's afforded to members is afforded to both voting and non-voting members.
Laurie, there's another question there for you. Maybe you just want to take a look at it, and I'll answer the next one while you're thinking about the one about the calculation of FMV. But another question that came in about public benefit corporations was, can you explain further about distribution of assets other than upon dissolution in a non-charitable public benefit corporation? Example, in the case of performance bonus or other ad hoc payments to members or staff. So I hope I'm not missing the point here, but I think you need to distinguish these two concepts. We only get into the issue of a distribution of assets on dissolution after all of the amounts have been paid to creditors of the corporation. So after you've already paid the amounts that are due to your employees, whether it's their regular salary or whether it's bonuses that they are entitled to. And only once all those creditors have been satisfied, then do we look at the distribution of those assets. Now, I don't think that you can say, oh, well, what we'll do is we'll eliminate that discussion by taking all of our funds and distributing them to our employees, because you can only pay your employees fair market value, right? So if they are entitled to a bonus under their contract or under your policies, then paying that bonus in a manner consistent with the policies or contract would be perfectly fine. But if you are paying an amount that is out of the ordinary course, that can't be justified as a fair market value payment, then that's probably an improper payment, whether it is called a distribution or otherwise. Victoria, we have one for you. Victoria, you referred to the 7-day notice period by which directors who were not at a meeting have to give notice to the secretary of the corporation that they do not support the motion that was passed. When does that 7 days run? Like, how do you know when the director became eligible?
That's a good question. I was going to say, the wording of the provision in the statute isn't all that clear. It says 7 days of becoming aware of a resolution being passed. Now, I guess there can be questions of when you do actually become aware. Potentially might be when you're reviewing the minutes from the previous meeting, for example, if you are absent. But there is always a possibility that, that an argument could be made that a director becomes aware of a resolution before reviewing those minutes. So in order to be to err on the side of caution, I'd say definitely register your dissent as soon as you find out about a possible resolution. But we'll see how this provision is applied, I guess, over time. But I guess I would say our interpretation right now is within the 7 days of you becoming aware, and I think it'd be reasonable to say once you see meeting minutes if you're absent, but again, there's always a possibility of making an argument that you would be aware of it sooner.
Thank you, Victoria. I certainly think it is good practice to be reviewing minutes as soon as you receive the minute, and maybe not the very day of, but probably a good practice to review them within that 7-day period. I know it's when you're a director of a number of companies, it's or busy, even a director of one company, but busy with other things. Sometimes those minutes only get reviewed just before your next meeting, but the better practice would be to do that review within 7 days of receiving them. Briana, someone has asked us about if there are any other statutes that apply to hospitals that would trump the ONCA.
Sure. If there's a conflict with the Income Tax Act, if the Charities Accounting Act, Excellent Care for All Act, any conflict with the ONCA, those special acts would prevail.
Okay, very good. And that's good to know too. I mean, the Income Tax Act is relevant for all non-share capital companies. So you can't rely just on the Corporations Act. You should be very familiar with the restrictions for those types of entities under the Income Tax Act. All right. There was another one down here for me. Sorry, everybody. Right down here. Now we can maybe look at this together, Victoria. Is the conflict of interest definition in the Act considered exhaustive? For example, it seems like a conflict of interest if the board is considering terminating the membership of a director's spouse or child, but that doesn't involve being a party to a contract as contemplated by the ONCA definition. Okay, so that's very interesting. Well, Victoria, maybe I'll take a crack at that if you don't mind.
Go ahead.
Okay, so first of all, the definition of conflict of interest in the statute is not exhaustive. The common law definition of conflict of interest could be broader. Also, you could have policies that you adopt that are broader than that. So when you are determining whether a conflict of interest exists, you need to for sure start with what is in the statute, which we would recommend you copy into your bylaw, and you should be looking at your policies as well. So then it says, so it's not exhaustive necessarily. And then the question is, all right, does it apply just to contracts? Well, as Victoria said, it's contracts or transactions. That is what's covered there. In terms of terminating the membership of a director's spouse or child, whether that would actually be conflict of interest at law would depend on a number of factors, including what types of rights people have by virtue of being a member. You know, if it's a membership in a gym where you actually get some rights from it, where somebody could have a financial interest in that decision versus, membership in an arts appreciation organization. So I think that this would have to be considered on a case-by-case basis. Victoria, any other thoughts for that one?
No, I think what is also just key, as you mentioned, Lynne, is to consider what conflict of interest policies the corporation might have in place specifically. And in fact, in order to deal with these potential issues that come outside of, what we would typically think of a contract or a transaction, it would be of significant benefit for a corporation to have a potentially thorough conflict of interest policy in place so that there might be more reference points to deal with an issue like this if it were to arise.
Yeah, I agree. Thank you. Laurie, are you able to answer that question now or?
So I think that, did you already announce the question? Sorry.
No, I did not.
Oh, okay. So there was a question about whether or not we had any thoughts on determining the fair value of a membership interest for the purposes of the dissent right, and whether it would include, in the case of a social club, for instance, an initiation fee. So there's not a lot of guidance on this. So the only thing that the Act specifically states in terms of the value is that when a member is entitled to receive the fair value of their membership interest, it includes any capital contributions. So that's number one. And then also, which I discussed as part of my presentation, which is not overly helpful, but that the court can apply or use an appraiser to help it determine the fair value of a membership interest. Otherwise, it seems as though the legislation is quite loose in terms of the fair value. Like, it provides the directors with the right to establish that fair value, and then they just have to provide the methodology by which they arrived at that value to the member, and then the member obviously has a right to appeal that. But otherwise, there's not a lot of direction on that.
I think it's going to be a very evolving area of the law because it's such a new concept in the not-for-profit world. There's another question about public benefit corporations. Could an entity be a public benefit corporation in one fiscal year and not in the next? And if so, when does the designation start and stop? Is it on the date of the fiscal year? So yes, this designation is only applicable on a year-by-year basis. So if you had more than $10,000 of gifts, grants in a particular fiscal year, and you don't in the next year, you don't meet that threshold, then you would cease to be a public benefit corporation. The designation starts and stops with your annual meeting, and it's based on the financial statements of the prior year. Victoria, there's a question here for you. If a director vacates mid-year and has 2 years left on their term, does the replacement director appointed by the board serve for the remaining 2 years or only until the next annual meeting? So this is a case, obviously, where a director was elected for 3 years or 4 years, and they resign midway through. Victoria, is there anything in the statute about that?
It does. There is. The Act says that a director who is reappointed to fill a vacancy, which would be the case here, would serve for the remaining unexpired term that is left. So if you're taking over someone's term and there's 2 years left, you would serve those remaining 2 years.
Very good. And here's another one for you, Victoria. There's language in the Act that delegation is possible to a committee of directors. Does that mean that if you have non-directors on a committee, it cannot be delegated any power of the directors to make decisions? Victoria, you able to answer that?
I'm pausing to say that question in my head. So I know, so there are certain powers that a director can delegate, but I would have to confirm specifically what those are in order to comment on this. So it might take me a moment to take a look, but it would depend. There are certain powers that directors certainly can't delegate, and those wouldn't be open to delegation.
Yeah, I can tell you that as a general matter, boards cannot delegate decision-making to committees that have non-directors on them. Now, I say that as a general matter. There are some things, as Victoria said, that can be delegated. So, for example, investment committees. Most charities or not-for-profits that have investment committees will have people on those committees who are really experts in financial matters and investment matters. And under the Charities Accounting Act, you can make a delegation of those sorts of powers. But as a general matter, boards really can't delegate their decision-making to a committee that has people on it that aren't directors. Laurie, there was another one for you. It was mentioned in the members' remedies part of your presentation that a proposal may include a nomination or nominations for directors. Does this mean that the members are not then permitted to nominate directors from the floor of the meeting?
That's a good question. And we often hear of disputes arising in the context of members trying to introduce motions or nominations from the floor. However, ONCA is really clear and specifically provides that despite the right of a member to make a proposal, members are entitled to nominate directors from the floor, even if that member hasn't submitted a proposal including any nominations prior to the meeting.
Yeah, no, I will say that my view is that you can draft a legitimate bylaw that limits nomination rights from the floor, but only if you provide an alternative method by which all members can participate in that nomination process. So, I think just for efficiency, and particularly with electronic meetings and votes by electronic means, it is understandable that sometimes we may want to know the entire list of potential nominees before the meeting. But as I say, if you adopt that process, you must have one that absolutely everyone who could have been nominated from the floor can be nominated in your pre-meeting process.
Yeah, I think that's a good point. And just to clarify, what the Act specifically says is in the context of members' proposals, it says that the right of a member to make a proposal to nominate a director doesn't preclude that member, or doesn't preclude members for bringing nominations for directors from the floor. So it doesn't actually say members are permitted to make nominations from the floor in all cases. It just says that this proposal right isn't intended to preclude nominations from the floor.
I agree with that. Another question for you, Laurie, is it says, I understand that the members have the right to remove directors in many cases. Can the board or the director, I guess, who's the subject of the removal, object or even override the removal?
So I think that in that case, as I had indicated in my presentation, there are a few instances where members can't remove directors. So for example, if the members passed a resolution to remove an ex officio director, then that wouldn't be valid, and the board could obviously step in and say that that wasn't a valid removal. However, the board generally doesn't have the right to, override the right of the members to remove directors. In terms of the director who's the subject of the removal or proposed removal, the director doesn't, of course, have the right to override a member's resolution to remove them. But the Act does give directors who the members propose to remove the right, being subject to the bylaws in all cases, however. So they have the right to submit reasons for opposing the removal. So they can provide a statement to the corporation which sets out the reasons why they're opposing the removal as a director. And in that case, if the corporation receives such a statement from a director, then the director or the corporation is required to circulate that statement of the director to each of the members. However, there's no real requirement otherwise for what the members have to do with that statement. So for instance, they don't have to respond to that statement or otherwise respond in any positive way.
Yeah. Picking up on the question prior to that, can bylaws limit director nominations to a slate proposed by the board? And this kind of carries on to the answer that I provided earlier. No, I don't think you can. You have to have some method by which anyone can put forward a name, and a process where you say, you can submit it to us and our nominations committee will consider it and we'll decide whether we're going to put that person's name on the slate. I do not believe that that will meet the requirements of the Act. Laurie, there was another one here for you. You referred to the COVID meeting transition provisions, the provisions in place, I should say, because of COVID. People are asking what those are about.
So there was recent amendments to the Corporations Act, which included provisions to say essentially that despite what the bylaws of a corporation provided, members and directors' meetings could be held by telephone or electronic means. And this was carried into effect in the context of ONCA. And as I said, it's until September 2022. So what that means is that even if a corporation's bylaws prohibit meetings of directors or members from being held by way of telephone or by electronic means, then during this period of time, so until September 2022, the corporation can nonetheless hold meetings by these means. But there are a few things to note. So if you hold a director's meeting by telephone or online, the directors also have to be able to either speak or listen or live chat to each other at the same time. So just being on the telephone, everybody on mute isn't sufficient. And also with respect to members meeting, there is some discretion still afforded to the corporation through the chair, and that in the case where a meeting of the members is held electronically, the chair can still has the power to decide how members will vote for election of directors, so they can ignore the bylaws and permit these elections to occur electronically. But I do note something that's been asked before is at the beginning of the pandemic, corporations were relieved of their obligations to hold annual meetings of members within a specified time period, and that has now ended. So because the legislation now permits corporations to hold these meetings electronically, they think there's no excuse and they should be held and no longer deferred.
Thank you. Laurie, you're popular. I've got two more for you. One relates to the treatment of religious corporations. It says, Laurie said that the right of members to seek a court order to commence a derivative action does not apply to members of religious corporations. What is meant by a religious corporation?
It's a good question. So unfortunately, despite the fact that the Act uses this term, it doesn't define it. But I think presumably this would be a corporation that would be established for the advancement of religion and would likely be a charitable corporation, therefore. However, I would caution that if this term becomes relevant to you, so if a right is only available where a corporation is not a religious corporation and it's kind of unclear to you whether or not you are a religious corporation, then I would just caution you to seek legal advice, given that there is a lack of clarity around this term.
Good point. And then there's this one. It says, I'm with a small corporation and I'm concerned about the right to requisition meetings occurring too often. We don't have the resources to hold frequent members' meetings. Do you have any thoughts on that?
I guess my first thought is, as indicated in the presentation, so the default under the legislation is that 10% of members who are entitled to vote on or at the meeting that's being requisitioned can requisition a meeting, but that's subject to a lower percentage being set in the bylaws. So of course, if you're a smaller organization and are concerned about the resources for holding members' meetings on a regular basis in response to requisitions, then of course you wouldn't include a lower percentage in your bylaws. I would try not to include any lower percentage in the bylaws and stick to that 10%. Unfortunately, you can't increase the percentage, but you can stick at that 10%. Again, just as a reminder, also, it does require 10% or whatever the amount is set out in your bylaws. So it would be necessary for the members, a certain number of the members or 10% of the members to take issue with something that's occurring or having a hot pressing matter. So I don't think there's any way to eliminate, the frequency, eliminate these meetings being requisitioned. But one way to perhaps minimize the use of requisitions is just to keep in touch with the members about their concerns and just provide a forum for those concerns and matters of interest for them to be addressed. And then if acceptable, comfort the members that, again, if acceptable, then the matter or their concern will be added to the agenda and addressed at the next meeting. And this will help eliminate meetings that are being held just for one-off matters in response to a requisition.
Thank you, Laurie. Okay, we are done our questions. I'm actually, there's one question left, and I'm going to get in touch with the author of that question directly. But there are no other questions, so I think our seminar is done. I want to thank all of you very much for attending. We were really excited about the response to our invitation for this. We are ready, willing, and able to assist you with the next processes as you transition to the new Act. We have lots of precedents available for you, and look forward to working with you as you, as I say, transition to the new Act. So thank you very much for being with us, and we'll see you again. Please complete the survey if you have not yet done so. Thank you.